Have you ever thought about making a small adjustment to an important document, perhaps to reflect it a new family member or a change in your wishes? It seems straightforward enough, but with legal papers, even a tiny change can have big consequences if not handled correctly. So, do you need a lawyer to change your will? The short answer is that while you can technically make changes yourself in some circumstances, it is highly recommended to involve a qualified attorney to ensure your updates are legally valid and effectively reflected your intentions. This is not just about avoiding simple mistakes. It is about protecting your legacy and ensuring your final wishes are honored without dispute. The primary reason for consulting a lawyer stems from the complex legal requirements surrounding wills. Each state has specific laws governing how a will must be drafted, witnessed, and executed. Even a minor change, like adding or removing a beneficiary, can inadvertently invalidate portions of your will or even the entire document if the proper legal procedures are not followed precisely. Lawyers understand these nuances, such as what constitutes a valid signature, the number of witnesses required, and how to create a codicil, which is a formal amendment to an existing will. Without this expertise, errors could lead to costly and time-consuming probate disputes for your loved ones, exactly what a well-drafted will aims to prevent. Deciding whether to engage a legal professional depends on the nature and complexity of the change you wish to make. If you are considering significant alterations, such as changing beneficiaries, appointing a new executor, or modifying how assets are distributed, a lawyer is almost always essential. They can advise you on the most appropriate legal instrument, whether it is a codicil or an entirely new will, and ensure all legal formalities are met. For simpler changes, like updating an address, you might be tempted to handle it yourself. However, even these small updates must strictly adhere to legal requirements to avoid any questions about their validity. Asking yourself if the change involves asset distribution or personal representatives is a good starting point to gauge complexity. An insider detail to be aware of is the concept of a self-proving affidavit. This is a document signed by the testator, who is the person making the will, and witnesses before a notary public, confirming the will's proper execution. Including a self-proving affidavit with your will or codicil can simplify the probate process by reducing the need for witnesses to appear in court. Another important term is revocation. If you decide to make an entirely new will, it must contain language that explicitly revokes all prior wills and codicils to prevent confusion or challenges to your latest wishes. These specific legal elements highlight why professional guidance is invaluable. Ultimately, ensuring your will accurately reflects your intentions and stands up to legal scrutiny provides immense peace of mind. By working with an attorney, you gain expert guidance through the intricate process of updating your will, preventing potential errors that could jeopardize your legacy and create unnecessary burdens for your family. It is an investment in clarity, security, and the reliable fulfillment of your final wishes.